let's say that you file a lawsuit as a plaintiff, and you say, okay, we've made a case for a certain cause of action or several causes of action, because typically there's more than one cause of action in a complaint. But there doesn't have to be. So you have a number of causes of action or one cause of action, and you are able to prove that. And then, as I stated, you have to go then to the damage part, and you say, okay, I can show you, Mr. or Mrs. Judge, or I can show you, the jurors, that these are the dollar amounts that I have suffered because of the other side breaching the contract or committing some type of act that is actionable in law, and the plaintiffs have actually proved that. So you get those compensatory damages because they compensate you for your loss. And then punitive or exemplary damages say, oh, by the way, what we want to do is we want to send a message to this particular company and to the community at large, and so we are going to add extra damages as a deterrent from you acting this way and from other persons that may be in similar types of businesses from acting in this manner, because you may sit there, especially if you're a big company, and you may sit there and say, okay, well, if we get sued on this, this is what the damages would be from a compensatory standpoint. And you may have somebody that is running that business, or persons that are running that business that says, you know what, that's the cost of doing business, and we make more than that, so we don't really care, and we'll go out and we'll commit these torts that are actionable, and if we get sued, we get sued. But even with attorney's fees, we're not going to lose money, we're going to make money if we keep taking this action. So then the court steps in and says, well, you know what, we're going to help the society at large from this happening, because we're going to tag this company with punitive damages. So we're going to punish them above and beyond what the plaintiff could prove they actually suffered monetarily or otherwise. We're going to add in additional damages to send a message to that company and to other companies not to continue in that type of behavior. And there are certain proof requirements that go above and beyond the requirements for compensatory damages. So you can't, I mean, attorneys do, but, it's not going to go very far if you just throw out a blank statement and go, oh, we want punitive damages as well. There has to be a basis for them, and you have to set forth certain criteria for pleading on those. But if you do that, then you may certainly be entitled to those, depending on how egregious the conduct of the plaintiff is found to be by typically the judge, but jurors as well. And then sometimes the judge has what's called either additor or omitter abilities, which means that they can add to that amount or they can reduce it. A lot of times, you'll see a jury, awarded, just to pick numbers out, and says, okay, you're liable for $80 million of compensatory damages, but we don't want you to do this again, so we're going to tag you, and we really don't like the lawyers on the other side. We don't like anybody. So we're going to recommend that or find that the damages are, for punitive damages, are $2 billion. And then the judge can come up and go, well, I understand punitive damages, I'm going to reduce those to $500,000 instead of $2 billion, to be fair. So that happens as well.